going to read the final instructions to all of you. I will send these back with you, a copy of them, so you don't have to take notes. And I will apologize in advance if they're sometimes repetitive. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Jimmy Ray Rodgers, the defendant in this case, has been accused of the crimes of first-degree murder, conspiracy to commit murder, and first-degree burglary while armed. In this case, Jimmy Ray Rodgers is accused of first-degree murder. Murder in the first degree includes the lesser crimes of murder in the second degree and manslaughter, all of which are unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Teresa Severs was killed by Jimmy Ray Rodgers, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder or was murder in the second degree, manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. When the killing is committed by accident and misfortune, and in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or two, when the killing occurs by accident and misfortune in the heat of passion, upon any sudden and sufficient provocation. Or three, when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. I now instruct you on the circumstances that must be proved before Jimmy Ray Rodgers may be found guilty of first-degree murder or any lesser included crime. There are two ways a person may commit first-degree murder. One is known as first-degree premeditated murder, and the other is known as first-degree felony murder. To prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. 1. Teresa Severs is dead. 2. The death was caused by the criminal act of Jimmy Ray Rodgers. And 3. There was a premeditated killing of Teresa Severs. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. To prove the crime of first-degree felony murder, the state must prove the following three elements beyond a reasonable doubt. 1. Teresa Severs is dead. 2. While engaged in the commission of a burglary, Jimmy Ray Rodgers or Curtis Wainwright caused the death of Teresa Severs. And 3. Jimmy Ray Rodgers was the person who actually killed Teresa Severs, or Teresa Severs was killed by a person other than Jimmy Ray Rodgers, but both Jimmy Ray Rodgers and the person who killed Teresa Severs were principals in the commission of burglary. In order to convict the defendant of first-degree felony murder, it is not necessary for the state to prove that the defendant had a premeditated design or intent to kill. To prove the crime of burglary, the state must prove the following two elements beyond a reasonable doubt. 1. Jimmy Ray Rodgers entered a structure owned or in the possession of Teresa Sievers. 2. At the time of entering the structure, Jimmy Ray Rodgers had the intent to commit theft or murder in that structure. You may infer that Jimmy Ray Rodgers had the intent to commit a crime inside a structure if the entering of the structure was done stealthily and without the consent of the owner or occupant. The intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. Even though an unlawful entering a structure is proved, if the evidence does not establish that it was done with the intent to commit theft or murder, the defendant must be found not guilty of burglary. Proof of possession by an accused of property recently stolen by means of a burglary, unless satisfactorily explained, may justify a conviction of burglary if the circumstances of the burglary and of the possession of the stolen property convince you beyond a reasonable doubt that the defendant committed the burglary. Structure means any building of any kind, either temporary or permanent, that has a roof over it and the enclosed space of ground and outbuildings immediately surrounding the structure. The enclosure not need be continuous, as it may be an ungated opening for entering and exiting. If you find Jimmy Ray Rodgers guilty of burglary, you must also determine if the state has proved beyond a reasonable doubt in the course of committing the burglary, Jimmy Ray Rodgers was armed or armed himself within the structure with a dangerous weapon. A dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. It is not necessary for the state to prove that the defendant intended to use or was willing to use the weapon in furtherance of the burglary in order for a weapon to constitute a dangerous weapon. Great bodily harm means, as distinguished from slight, trivial, minor, or moderate harm, and does not include mere bruises. If you find Jimmy Ray Rodgers guilty of burglary, you must also determine if the state has proved beyond a reasonable doubt whether the structure entered was a dwelling. Dwelling means any building of any kind, whether such building is temporary or permanent, mobile or immobile, which has a roof over it and is designed to be occupied by people looking therein at night, by people lodging rather therein at night, together with the enclosed space of ground and outbuildings immediately surrounding it. The enclosure need not be continuous, as it may be an ungated opening for entering and exiting. For purposes of a burglary, a dwelling includes an attached porch or attached garage. An act is committed in the course of committing if it occurs in the attempt to commit the offense or in flight after the attempt or commission. If the defendant helped another person or persons commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the defendant had a conscious intent that the criminal act be done and the defendant did some act or said some word which was intended to and which did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. To be a principal, the defendant does not have to be present when the crime is committed. To prove the crime of criminal conspiracy, the state must prove the following two elements beyond a reasonable doubt. 1. The intent of Jimmy Ray Rodgers was that the offense of first-degree murder would be committed. And 2. In order to carry out the intent, Jimmy Ray Rodgers agreed, conspired, combined, or confederated with Mark Sievers and Curtis Wainwright to cause the death of Teresa Sievers to be committed either by them or one of them or by some other person. It is not necessary that the agreement, conspiracy, combination, or confederation to commit first-degree murder be expressed in any particular words or that the words passed between the conspirators. It is not necessary that the defendant do any act in furtherance of the offense conspired. It is a defense to the charge of criminal conspiracy that Jimmy Ray Rodgers, after conspiring with one or more persons to commit the first-degree murder, persuaded Mark Sievers and Curtis Wainwright not to do so, or otherwise prevented commission of the first-degree murder under circumstances indicating a complete and voluntary renunciation of his criminal purpose. Renunciation is not complete and voluntary where the crime that was conspired to was not completed because of unanticipated difficulties, unexplained resistance, a decision to postpone the crime to another time, or circumstances known by the defendant that increased the probability of being apprehended. If you find that the defendant proved by a preponderance of the evidence that he persuaded Mark Sievers and Curtis Wainwright not to commit the first-degree murder or otherwise prevented commission of the first-degree murder under circumstances indicating a complete and voluntary renunciation of his criminal purpose, you should find him not guilty of conspiracy to commit first-degree murder. If the defendant failed to prove by a preponderance of the evidence that he persuaded Mark Sievers and Curtis Wainwright not to commit first-degree murder, or that he did not otherwise prevent commission of the first-degree murder under circumstances indicating a complete and voluntary renunciation of his criminal purpose, you should find him guilty of conspiracy to commit first-degree murder if all the elements of the charge have been proven beyond a reasonable doubt. To prove the crime of burglary, the state must prove the following two elements beyond a reasonable doubt. 1. Jimmy Ray Rodgers entered a structure owned by or in the possession of Teresa Sievers. 2. At the time of entering the structure, Jimmy Ray Rodgers had the intent to commit theft or murder in that structure. You may infer that Jimmy Ray Rodgers had the intent to commit a crime inside a structure if the entering of the structure was done stealthily and without the consent of the owner or occupant. The intent with which an act is done is an operation of the mind and therefore is not always capable of direct and positive proof. It may be established by circumstantial evidence like any other fact in a case. Even though an unlawful entering a structure is proved, if the evidence does not establish that it was done with intent to commit theft or murder, the defendant must be found not guilty of burglary. Proof of possession by an accused of property recently stolen by means of a burglary, unless satisfactorily explained, may justify a conviction of burglary if the circumstances of the burglary and of the possession of the stolen property convince you beyond a reasonable doubt that the defendant committed the burglary. Structure means any building of any kind, either temporary or permanent, that has a roof over it and the enclosed space of ground and outbuildings immediately surrounding that structure. The enclosure need not be continuous, as it may have an ungated opening for entering and exiting. If you find Jimmy Ray Rodgers guilty of burglary, you must also determine if the state has proved beyond a reasonable doubt whether in the course of committing the burglary, Jimmy Ray Rodgers was armed or armed himself within the structure with a dangerous weapon. A dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. It is not necessary for the state to prove that the defendant intended to use or is willing to use the weapon in the furtherance of the burglary in order for a weapon to constitute a dangerous weapon. Great bodily harm means great, as distinguished from slight, trivial, minor, or moderate harm, and as such does not include mere bruises. If you find Jimmy Ray Rodgers guilty of burglary, you must also determine if the state has proved beyond a reasonable doubt whether the structure entered was a dwelling. Dwelling means a building of any kind, whether such building is temporary or permanent, mobile or immobile, which has a roof over it and is designed to be occupied by people lodging therein at night, together with the enclosed space of ground and outbuildings immediately surrounding it. The enclosure need not be continuous, as it may have an ungated opening for entering and exiting. For purposes of burglary, a dwelling includes an attached porch or attached garage. An act is committed in the course of committing if it occurs in the attempt to commit the offense or in flight after the attempt or commission. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crimes of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime or crimes. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of first-degree murder are second-degree murder and manslaughter. The lesser crimes indicated in the definition of first-degree burglary while armed are burglary of a dwelling, burglary, trespass while armed, and trespass. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1. Teresa Severs is dead. 2. The death was caused by the criminal act of Jimmy Ray Rodgers. And 3. There was an unlawful killing of Teresa Severs by an act imminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is imminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another, and is done from ill will, hatred, spite, or evil intent, and is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. If you find that Jimmy Ray Rodgers committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, used, or attempted to use a weapon, you should find him guilty of second-degree murder with a weapon. A weapon is legally defined to mean any object that could be used to cause death or inflict serious bodily harm. If you find that Jimmy Ray Rodgers committed second-degree murder, but you are not convinced beyond a reasonable doubt that he carried, used, or attempted to use a weapon, then you should find him guilty only of second-degree murder. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1. Teresa Severs is dead. 2. Jimmy Ray Rodgers intentionally committed an act or acts that caused the death of Teresa Severs. Jimmy Ray Rodgers intentionally procured an act that caused the death of Teresa Severs. The death of Teresa Severs was caused by the culpable negligence of Jimmy Ray Rodgers. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. To procure means to persuade, induce, prevail upon, or cause a person to do something. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard for human life or the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. If you find that Jimmy Ray Rodgers committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime he personally carried, used, or attempted to use a weapon, you should find him guilty of second-degree murder with a weapon. A weapon is legally defined to mean any object that could be used to cause death or inflict serious bodily harm. If you find that Jimmy Ray Rodgers committed second-degree murder, but you are not convinced beyond a reasonable doubt that he carried, used, or attempted to use a weapon, then you should find him guilty only of second-degree murder. To prove the crime of trespass in a structure, the state must prove the following three elements beyond a reasonable doubt. 1. Jimmy Ray Rodgers willfully entered or remained in a structure. 2. The structure was in the lawful possession of Teresa Sievers. 3. Jimmy Ray Rodgers entering or remaining in the structure was without authorization, license, or invitation by Teresa Sievers or any other person authorized to give that permission. Authority to enter or remain in a structure need not be given in express words. It may be implied from the circumstances. It is lawful to enter or remain in a structure of another if, under all the circumstances, a reasonable person would believe that he had the permission of the owner or occupant. Person authorized means an owner or lessee or his or her agent or any law enforcement officer whose department has received written authorization from the owner or lessee or his or her agent to communicate in order to depart the property in case of a threat to public safety or welfare. Willfully means intentionally, knowingly, and purposely. Structure means any building of any kind, either temporary or permanent, that has a roof over it and the enclosed space of ground and outbuildings immediately surrounding that structure. If you find Jimmy Ray Rodgers guilty of trespass in a structure, you must then determine whether the state has proved beyond a reasonable doubt that Jimmy Ray Rodgers was armed or armed himself with a dangerous weapon during the trespass. A dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. If the defendant helped another person or persons commit a crime, the defendant is a principal and must be treated as if he had done all the things the other person or persons did if the defendant had a conscious intent that the criminal act be done and the defendant did some act or said some word which was intended to and which did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. To be a principal, the defendant does not have to be present when the crime is committed. If you find that the crime alleged was committed, an issue in this case is whether the crime of first-degree murder was an independent act of a person other than Jimmy Ray Rodgers. An independent act occurs when a person other than Jimmy Ray Rodgers commits or attempts to commit a crime, which Jimmy Ray Rodgers did not intend to occur, and in which Jimmy Ray Rodgers did not participate, and which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by Jimmy Ray Rodgers. If you find Jimmy Ray Rodgers was not present when the crime of first-degree murder occurred, that in and of itself does not establish that the first-degree murder was an independent act of another. If you find that the first-degree murder was an independent act of Curtis Wayne Wright, then you should find Jimmy Ray Rodgers not guilty of the crime of first-degree murder. The defendant has entered a plea of not guilty. This means you must presume or believe the defendant is innocent. The presumption stays with the defendant as to each material allegation in the indictment through each stage of the trial unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It's the evidence introduced into this trial and to it alone that you're to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with the other testimony and other evidence in the case? Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who hopes to gain more favorable treatment in his or her own case may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendant. It is not necessary for the defendant to disprove anything, nor is the defendant required to prove his innocence. It is up to the state to prove the defendant's guilt by evidence. The defendant exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by the defendant outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to whether when the defendant made the statement, he had been threatened in order to get him to make it, and whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only on the evidence that you've heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. You may find the defendant guilty as charged in the indictment or guilty of such lesser included crimes as the evidence may justify, or not guilty. If you return a verdict of guilty, it should be for the highest offense that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you. It is as follows. I'll walk through the verdict form, if I can find it. It's a 3-page document that we'll be sending back with you, and it has the first count in the indictment, first-degree murder. Once you have a unanimous verdict, you will check only one of the boxes under that, A, B, C, or D. A reads, the defendant is guilty of first-degree murder. B reads, the defendant is guilty of second-degree murder. If you choose B unanimously, you have to answer the question below, which reads as follows. Do you unanimously find beyond a reasonable doubt that the defendant carried, used, or attempted to use a weapon? You would have to have a unanimous decision to that question as well with yes or no. If you choose C reads as follows, the defendant is guilty of manslaughter. If you unanimously choose that one, you will have to answer the question below. It reads as follows. Do you unanimously find beyond a reasonable doubt that the defendant carried, used, or attempted to use a weapon? You would have to have a unanimous decision to that as well and check either yes or no. D reads the defendant is not guilty. If you choose A or D, you do not need to answer the questions below, and you only need to answer a question below if that's the one you check unanimously. The next is the second count, conspiracy. You will check only one once you have a unanimous decision. A reads, the defendant is guilty of conspiracy. B reads, the defendant is not guilty. As to the last count, burglary, you will either check A, B, or C once you have a unanimous verdict. A reads, the defendant is guilty of burglary. If you check that box, you have to answer the questions below. If you don't check that box, you don't have to answer those questions. The questions below A read, do you unanimously find beyond a reasonable doubt that the structure was a dwelling? You'll have to have a unanimous answer to that if you check A, either yes or no. And the next question reads, do you find unanimously beyond a reasonable doubt that the defendant was armed or armed himself within the structure with a weapon? Again, you only have to answer that question if you check A, and you'll have to have a unanimous answer, yes or no to that question. B reads as follows, the defendant is guilty of trespass. If you unanimously check that box, you'll have to answer the question below. The question reads, do you unanimously find beyond a reasonable doubt that the defendant was armed or armed himself within the structure with a weapon? You would have to have a unanimous answer to that if you check B, either yes or no. If you check C reads, the defendant is not guilty. If you check C, you don't have to answer any of the other questions in that section. There's a place for the foreperson to date the form and to sign it and to print their name when they come back to the courtroom. If you return a verdict of guilty to the charge of first-degree murder, it is not necessary that all of you agree the state proved first-degree premeditated murder, and it is not necessary that all of you agree the state proved first-degree felony murder. Instead, what is required is that all of you agree the state proved either first-degree premeditated murder or first-degree felony murder. A separate crime is charged in each count of the indictment, and although they've been tried together, each crime and the evidence applicable to it must be considered separately, and a separate verdict returned as to each. A finding of guilty or not guilty as to one crime must not affect your verdict as to the other crimes charged, except as explained in the instruction for legally interlocking counts. The charge of first-degree felony murder and the special finding associated with that charge are interrelated because a special finding that the defendant committed a burglary is an essential element of first-degree felony murder. Accordingly, you should not return a verdict finding the defendant guilty of first-degree felony murder unless you also find in the special finding that the state proved the allegation that the defendant committed burglary. On the other hand, if you decide that the allegation that the defendant committed burglary in the special finding for count 1 has not been proven beyond a reasonable doubt, then you should not return a verdict finding the defendant guilty of first-degree felony murder. In just a few moments, you'll be taken to the jury room by the court deputy or bailiff. The first thing you should do is to choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another, and only when all jurors are present in the jury room. If a juror does go to the restroom, the deliberation should stop until the juror returns. You are not to communicate with any person outside the jury about this case until you've reached a verdict. Anyone about this case. And until you've reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as a blog, Twitter, email, text message, or any other means. Do not contact anyone to assist you during your deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the bailiff. Many of you have cell phones, tablets, laptops, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those types of electronic devices into the jury room. Kindly leave those devices on your seats or the front rail where they'll be guarded by the bailiff while you deliberate. If you need to communicate with me, send a note through the bailiff. If you have voted, do not disclose the actual vote in your note. If you have a question, I'll talk with the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions, if I can, in writing or orally here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberations. The exhibits will be sent into the jury room with you when you begin to deliberate. If you wish to see any exhibits not sent into the jury room, please ask for them in writing. I'll send everything back that I can. I can't send back anything that would be considered a biohazard. I can't send back any of the videos or anything that you would need to play on the overhead because you don't have the capability to do that in the back. So if I don't send something, if there's something you want to see again or review again that I haven't sent back, just ask it for that in writing. We'll let you come out. You can watch it as many times as you would like or view it as long as you would like and as often as you would like. You just have to let us know. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules we all share. I'm attaching to the back of the instructions a couple of the special instructions that we gave you during the course of the trial. If you want to review those again, you may, but they've already been read to you. Again, I will send these instructions back with you